David, how are you doing?
I'm doing well. Can you hear me?
Yes.
Excellent. This means this is all working. This is great.
Half the battle.
Yes. In these times, sometimes even more than half.
Very true, very true. We had about 12 people sign up, I believe, so we've still got a few minutes. I know the 1Ls get out right at 2 o'clock, so we may just need to hold off until like 2:02 or so.
No problem.
Cool. I'm just finishing up making my lunch, so if you have any questions, I'll still have my sound on, but I may not be at the computer, so just give me a second and I'll be right back.
Sure. Well, I'm just going to take the opportunity to make sure that my screen sharing is working.
Cool.
Yeah. Get that in process. Excellent. Well, hopefully you can see my PowerPoint presentation.
I can see it.
Wonderful. That bodes well. It's all going to work out.
I like the background you have going on there. But it's the background behind you, not on the PowerPoint.
What's up?
I like the background you have behind you on your screen.
Oh, thank you. Thank you. Yeah. In these times of everything being remote, our communications department decided that rather than deal with the vicissitudes of however the backdrops in our various home offices might look, they would just send us these nice like cloth hangings that we could stick behind us.
Yeah, I like it a lot. I want one myself.
Yeah, no, it's a pretty sweet deal. And it was way cooler than I anticipated. I thought it would just be like something I tacked up, but it like has a little frame. It all works out.
Oh, nice. Perfect.
Yeah. All right. Well, I think we're just waiting for people to have a little more time to show up, and I'll just hang out and start whenever I am told to.
Yeah, we can just wait another minute or so. I see we've got most of the people that signed up. Yeah, maybe just like another minute.
Yeah, no worries. Friday afternoons tend to be a less intensely scheduled period for me. So y'all probably have more constraints on your time than I do at this point. Yes, I have a cat to take to a vet this afternoon, but otherwise I am here as long as you want me.
All right, I think we can probably just go ahead and start. And if the last few people just join late, that's totally fine.
Sure. Do you want me to just launch in? Do you have, I don't know if you have any chapter business to do first or anything you wanted to say. So let me know.
No, I think we're good. You can just go ahead and take it away.
All right. Excellent. Well, I'm very pleased to get to talk with all of you. And as you can see, we're talking about mass animal cruelty cases. And so I want to give you some context, both for where I'm coming from in terms of this topic and what we're talking about today. And it looks like there are about, 9 of us on the call. So that gives us a luxury in terms of how we deal with this. I had been planning, just to be safe in terms of time, to do sort of a 45-minute talk and then do Q&A. Given that there are relatively few of us, we could discuss as we go. That is up to you. Let's do this. I will talk. I will plan to have some time at the end for Q&A, but as I'm going, if you're like, I have a comment or a question, something has occurred to me and I should say it now before it escapes me, say something and we'll just talk from there. And it's probably better if you just verbally say it, because I am only seeing a certain number of you on the screen at a time right now. So gesticulating wildly may or may not work. So that logistical stuff said, who am I? I am David Rosengard. I'm a senior staff attorney with the Animal Legal Defense Fund's Criminal Justice Program. What does that mean? So as you probably know, being one of the ALDF student chapters, the Animal Legal Defense Fund is the nation's preeminent nonprofit organization devoted specifically to advancing the interests of animals and protecting their lives through the law. There are a lot of groups that do animal-related work. A lot of groups do work involving animal law. Our mission is specifically animal law and specifically using animal law on behalf of animals, both individually and structurally, in terms of changing legal systems to better accommodate animals and their unique interests and needs. Within that, the criminal justice system is a full-service criminal shop. We deal with anything that impacts animals within the context of criminal justice. So historically, we work a lot with law enforcement, animal control officers, lawmakers, and prosecutors, doing everything from talking about best practices in terms of investigation, through building a competent case, through passing better laws on behalf of animals. And I could talk about the historical reasons why that's where animal law at ALDF started. In recent years, we've expanded to working with judges, working with members of the victim rights community, and working with the defense bar to the degree that we acknowledge, we all stipulate that when it comes to questions of whether or not a crime matters when the victim was an animal, the defense bar may have different answers than we do. Our answer is, of course it matters. Some defense attorneys are going to argue on behalf of their human clients, this doesn't matter, it's an animal. And that's not an area where we can, of course, support them. But when we get into sort of more nuanced areas around criminal justice, there are some commonalities between defense work and what we do. Specifically, in terms of the context I come from, to give you the short version, I came into animal law after a career in higher ed, where, among other things, I worked in restorative justice systems. I got my JD, I did my animal law LLM at Lewis and Clark Law School, and I predominantly focus on constitutional and criminal issues as they relate to animal law. And one of the specific areas of passion I have is framing of animals as crime victims. I really see myself as a crime victim attorney for animals. So that colors the context I come from. So that's who I am. That's what's the perspective from which I speak. What laws are we talking about today? And acknowledging that all of you may be looking at practicing in different areas of the country, I'm not going to go into great detail on specific state laws, but generally speaking, I'll break the laws we're talking about today up into two areas. We've got federal laws, which are going to largely consist of laws against animal fighting, laws against crush video production, distribution, and laws that impact cruelty that involves significant harm to animals. In this last area, you may be wondering, that sounds vague. It is vague because that is coming out of the PACT Act, which passed Congress just at the end of last calendar year and has not significantly had the chance to be litigated yet. So there is, you may have heard coverage arguing that there's now a federal cruelty law. That is true to the extent that we now have a law that addresses a broad range of conduct against animals. There is a threshold for how bad that conduct needs to be. And of course, because this is a federal law, there is a interstate, intertribal, international commerce hook that you need to cover. All of that said, the place where the vast majority of cruelty work happens in the United States continues to be at the state law level. And there, I would generally break state cruelty laws up into four broad areas. There's laws against proactive cruelty, so torture, beatings, abuse, someone choosing to actively injure an animal. Passive cruelty, what we often think of as animal neglect, withholding of food, withholding of water, failure to provide minimum shelter, failure to provide minimum veterinary care, laws against animal sexual exploitation, and laws against animal fighting. And I'll beg your pardon, I'm at fear developing a bit of a sore throat, so I'm going to take a moment and drink some water. So, what is a mass cruelty case? The topic that I understand y'all are interested in discussing today. So this is not a legal definition. You're not going to find statutes that talk about mass cruelty, but it is a useful definition because cases that fall into this area are really going to have different implications in terms of how we respond to them as animal lawyers and how we respond to them as actors within the criminal system. And for our purposes, I think it's useful just to think about these as cases where there are an unusual amount of animals impacted or involved. And that's what we'll be talking about today. A note on images, I'm not going to use a lot of grotesque imagery directly from cases. I find that can often be disconcerting and distracting for people, and I think it's better for us to remain focused on the legal issues involved. Certainly, if you want to see what is happening to animals in these cases, a quick Google search will accommodate you. You can have that up on one tab. You can play some Sarah McLachlan in the other. You'll get the full Arms of the Angels experience, but we don't need to do that necessarily in this presentation. So, talk about some of the kinds of cases that we see. So one of the case facts that comes up often in mass cruelty cases is hoarding. And it's worth noting that hoarding in and of itself is not a crime. There historically has been one state, Hawaii, that statutorily defined hoarding as a crime, and that statute sunsetted and expired some years ago. So rather than someone being charged with hoarding, hoarding describes a constellation of behaviors, attitudes, and perspectives that a defendant, a perpetrator may have towards animals. And this typically involves a mental health component. Most typically, an animal hoarder has what amounts to some degree of dysmorphia relating to how they interact with animals, how they see the animals that they are surrounded by, and a difficulty regulating how many animals they're responsible for. What do I mean by that? Hoarders often have difficulty limiting how many animals they take in, and they may quite literally have difficulty appreciating the reality of the conditions that the animals are living in. So often you'll have people who have more animals than they have resources to care for, more animals packed into a space than the animals can safely and healthily live in, and the hoarders may not, at a mental health issue, and may not realize that the animals are suffering. They may honestly, in the same way that someone with body dysmorphia may have difficulty accurately assessing their own body condition, a person with hoarding may have difficulty accurately assessing the health and condition of their animals. In other cases, in other scenarios, hoarders may have some implicated paranoid behavior where they acknowledge that the animals are suffering, but they feel that veterinarians or the medical establishment or the world outside their control is a greater threat to the animals. Occasionally, hoarders will, for example, argue in court that animals that have been seized from their property should not be given medical care by the government because the veterinarians of the world are conspiring to murder the animals. Thankfully, this is an argument that is increasingly ineffective, and I can discuss if you'd like some case law around that, but it can be problematic when you have someone who files motions saying, the government cannot provide my animals with vaccinations, cannot provide my animals with emergency medical care, because the animals don't stay in a static state. Animals that are seized in a hoarding situation, as with any cruelty situation, require food, shelter, medical care in order to, at the very minimum, maintain where they are, if not, improve. And any legal maneuver that delays that tends to negatively impact the animals. So what sort of crimes are hoarders charged with? What sort of crimes are associated with this? Often we're looking at animal neglect crimes, i.e. passive cruelty, failure to provide sufficient food, water, housing, maintaining the animals in disease-ridden, parasite-ridden conditions. Also, often in hoarding, we'll see some unlicensed practice of veterinary medicine charges. And that's particularly true when the pathology of hoarding involves this sort of paranoid element where hoarders may be unwilling to turn towards legitimate veterinary medicine in order to meet their animals' needs. They may take to trying to provide veterinary care according to their own idiosyncratic notions of what is appropriate. Another set of mass cruelty cases we see involve animal fighting. And animal fighting is illegal throughout the nation as a crime in and of itself at both the federal and state level. And most often this involves dogs and roosters. And animal fighting cuts across broadly any range of demographics, any range of class, any range of race. The one demographic constant that tends to hold in terms of animal fighting is that the trainers and fighters themselves tend to be male. There's a whole separate conversation about sort of the way that animal fighting deals with and plays against gender norms and norms of expected behavior in terms of masculine versus feminine behavior. Women can and often are involved in roles outside of training and fighting. So animal fights tend to be large organized criminal operations. So you've got the trainers, you've got the fighters who are actually preparing the animals and putting the animals in the ring. You also have a host of other facilitators doing everything from running gambling operations, providing food and refreshment services, providing security services, taking tickets at the door for animal fights, and you have a host of other collateral crimes. By their nature, animal fights, because of that organized degree and because animal fighters don't want people coming and going because that could attract attention, organized fights tend to be lock-in affairs for an entire day. Everyone shows up early in the morning, the facility is locked down, everyone leaves at night when things are done. And if you are engaged in criminal activity, this is a great venue to engage in other criminal transactions. So as a result, animal fighting events tend to turn into big criminal swap meets. You've got drug deals, you've got gun running, you've got sex trafficking, because you've got a really receptive, safe audience to do that kind of work in from a criminal perspective. And so that's the kind of thing we see people charged in animal fighting. There's charges related to the training, there's charges related to direct fighting and facilitating, there are charges related to gambling, there's all these collateral crimes, and in some jurisdictions, you'll get RICO charges, organized crime charges, which are appropriate because, again, by its nature, animal fighting involves a significant amount of animal victims because you can't have fights without a lot of fighters. particularly because the fights tend to be pretty lethal. And you can't have fights without an organized sort of criminal operation to bring the humans doing the gambling and the fight preparation together. Another set of susceptible case facts are breeders, rescues, and zoos. And it's important to note here that the core conduct involved is legal. This is distinct from, for example, animal fighting, where animal fighting writ large is a criminal act. It is perfectly legal to breed animals, to run around an animal rescue, to have a zoo. Where we tend to see this come up in terms of mass cruelty cases is when specific conducts or conditions at these facilities violate the law. So breeders who are running what is often referred to as a puppy or cat mill or any other sort of mill operation, where animals are being bred at a rate and in a manner that the legal needs of the animals, the legal interests of the animals in getting minimum care, minimum shelter, minimum food, being protected from suffering, are not being met, because the breeder is serving an economic incentive to churn out animals and prioritizing that over the animal's well-being and the animal's legal needs. We see that in terms of rescues, both in terms of rescues that get in over their head, that start with the best of intentions and end up with more animals than they have the resources or knowledge to take care of. We also see that in terms of sham rescues, where there may not necessarily be that sort of good intent to start with, but the rescue structure may be a convenient way to extract donations from the public and receive public support for something that is in reality a cover for hoarding or fighting or some other criminal operation. Similarly with zoos, some zoos are operating legitimately within the criminal context. Other zoos prioritize economic incentive over the well-being of the animals and the legal imperative to provide the animals with the help they need. Yet other zoos start out with good intentions and get in over their heads. Really, so in this context, we're looking at the full range of potential criminal behavior, often passive cases involving neglect, but also active cases involving proactive cruelty. And one of the key issues is going to be, how visible is that conduct? How visible are the conditions? And is that conduct being reported to authorities? Is someone able to intervene? Similarly, in terms of visibility and reporting, farmed animal cases almost always implicate mass cruelty, because by their nature, farmed animals tend to come in flocks or herds. Very rarely, if you have someone engaged in farming operations, and this is distinct from someone who has one or two backyard chickens as companions, or who has a goat because they love goats, or a pig because they've got a pig that lives in their house and is their companion. When someone is raising animals as part of a farming operation, almost by definition, you're having a large number of animals, because that's the only way to make the farming operation economically viable. And one of the issues we often run into is the question of whether farmed animals are covered by cruelty law. And I know in the animal law space, we often, I think, for ease of discussion, shortcut to saying animals are exempt from cruelty law. And there are reasons why we say that. And I'll get to those reasons in a moment. But I would encourage you to avoid the temptation to engage in that shortcut, because the reality is animals are covered by cruelty law. There is no state in the nation where you can do whatever you want to any animal and say the fact that this animal is living in a farm context excuses the behavior. There are, however, carve-outs. So some animals, depending on the jurisdiction, are going to be excluded from the very definition of animal. For example, if you are in Arkansas, Arkansas's animal cruelty code doesn't include poultry in the definition of animal. So if you're a bird in Arkansas, I've got really bad news for you in terms of being able to protect your legal interests under cruelty law. Other jurisdictions are going to exclude specific types of conduct from the elements of the crime. So for example, in California, cruelty is essentially unjustifiable or unnecessary suffering or harm. So slaughtering an animal for food is justifiable. within that context. It's necessary if you look at the end result being the necessity of producing an animal flesh product. We can have a separate conversation about whether that is necessary in a moral or policy standpoint. Within the specific envelope of criminal law, it's going to meet the necessity threshold. And therefore, you're never going to start to argue about whether it is cruelty or not, because you just don't have the elements you need of the crime. And then there are going to be a third set of jurisdictions where something that would otherwise meet the elements of cruelty is going to be explicitly exempted. So these will be jurisdictions that say things like, it is presumptively cruel to mutilate an animal, that is, to fundamentally change an animal's bodily state, unless you're doing that for XYZ reason. And that reason will include things like spaying and neutering dogs and cats. It will also include things like accepted animal husbandry practices, which is what allows birds to be debeaked, cows to be dehorned, pigs to be, male pigs to be castrated without the use of anesthetics, and so forth. All of that said, acknowledging those loopholes, there is still a lot of ground to use cruelty law to protect farmed animals. Starving a farmed animal is not typically going to be exempt. Beating a farmed animal in an egregious way is not typically going to be exempt. Torturing a farmed animal is never going to be exempt unless you're doing it to a bird in Arkansas, or you're in another state where an animal just doesn't count as an animal. And so this again is a place where we tend to see mass cruelty cases arise. A final area that I want to draw your attention to, and this may be, I know, a bit provocative, but I think it's worth noting, is wildlife crimes. And similar to farming, hunting is generally legal in every jurisdiction in the United States, a caveat for Washington, D.C. But there are also generally regulations on what makes hunting legal. Generally, it's legal when you're hunting in accord with proper licenses, hunting seasons, bag limits, and so forth. And that's a separate question from whether it is possible for hunting to constitute criminal cruelty. So while hunting is legal, the fact that you can engage in lawful hunting does not make anything you do to an animal excusable under the guise of hunting. You cannot, for example, capture and torture a wild animal and say, I'm hunting the animal, what I'm doing is legitimate. There are not a lot of hunting organizations, for example, that will say, we go hunting for raccoons with chainsaws. That's not a thing. And if the defense wants to raise that, I will happily get into an argument with them about whether that constitutes a legitimate hunting practice and is exempt. Also, in many jurisdictions, the exemption for hunting applies only to lawful hunting practices. And so poachers, people who are hunting illicitly, are not necessarily going to be able to enjoy that exemption. And I underscore this because it points to an important issue going on in wildlife cases, which is wildlife crimes can often involve two separate kinds of crime. There's a crime against the state, ultimately amounting to resource theft, stealing animals, as it were, that are the state's to divvy out. And then there's a crime against potentially the animal themselves. And that crime looks at how was the animal treated and was that treatment legally justified? Part of the decision we've implicitly made in American law is to say certain kinds of hunts are legally justified and don't amount to criminal cruelty because we as a society have decided to value hunting. And again, we can have a policy conversation about whether that's the right value decision, but legally, we have decided that certain kinds of hunting are exempt from cruelty law, but that still preserves space for hunting that doesn't fall within that exemption to be recognized as being unjustly cruel, as being cruel conduct towards an animal that isn't made legitimate by according with our value system. So let me pause quickly and see if anyone has questions about these case facts, and then we'll get into what we do with all of that and some of the case law. And I've got about 20 minutes. I think I'll stick that number and we'll have some time at the end for Q&A. He said, cleverly buying himself a moment to get a drink. Okay, onward. So, some implications for your scene, for your search, for your seizure. The most important thing to remember in mass cruelty cases is that you work the scene just like any other crime. When law enforcement agents, animal control agents walk into a mass cruelty scene, the sensory overload and the empathy overload is often overwhelming. In hoarding situations, you may be assailed with literally toxic levels of ammonia. The smell from a hoarding case sticks to you and seeps into your clothing. It is a overpowering sensation, and one that is extremely hard not to react to. And there's an understandable urge for hoarding cases, for any other case where you walk in and are confronted by a large amount of victims, to get the animals out immediately, to get them help immediately. And I understand that reaction, and that is a good empathic reaction to have. It is also important to engage in what I like to call the Spock principle, which is you need to temper that reaction with the logical requirements of your case. So as you are gathering the animals and getting them the help they need, it is important to, without risking the animals' health and well-being, ultimately methodically assess, inventory, and document the animals. So if you have an animal that needs to be seized right now and rushed to the vet so the animal doesn't die, do so. But if the animal can stay where they are for a moment, so you can photo the animal, identify the animal, you can see here we've got a placard with a specific number for the animal, and you can get an idea of where the animal was in the crime scene. That's going to be very important, because when you're charging these cases, in order to avoid only being able to issue a generic charge that encompasses all the animals under one count of neglect, you need to show each separate animal impacted. So you need to be able to say, we have 5 cats that were being neglected, and we can identify who those 5 are, even if they all look very similar to each other, which is why you want identification, you want placards. If you're dealing with livestock, you want to be able to use a temporary pin to write a number on their side. And you want to work systematically. You want to go through the scene in an organized way, and you want to be methodical and purposeful about that. Your animals on a crime scene are unique from other kinds of victims and unique from other sorts of evidence because they move around on their own. And if you're not very careful, you're likely to miss animals. It's going to be a chaotic situation, and you need to control the scene. Anticipate that your animals are going to be scattering. They may be scared of you. They may be hiding. And it's important to take steps to get the scene under control and document it thoroughly as you are working to get those animals help. So some case law on this. And here I'm going to point us to specifically US versus CHILINSKI. And this really gets into who can be present during a search. Because as you can imagine, going back to our chaotic scene, if we've got animals everywhere, one of the issues that you're going to deal with is, how do you deal with all these animals? And most animal control agencies, most law enforcement agencies don't have the resources at a moment's notice to corral 100 goats or deal with 50 cats running around or a bunch of dogs or what have you. And so they'll bring in third parties, animal rescue groups, to help them with this. And here we turn to the Wilson-Hanlon rule. That's a set of federal Supreme Court cases that dig into third-party presence and create the rule that says essentially having a third party present in someone's private space during a search and seizure is a presumptive violation of the defendant's constitutional rights, certainly if that third party is acting for private purposes, the exception being that if that presence is related to the authorized intrusion or furthers the purposes of the search, then it's legitimate. So we look to why that third party is there. So how does this play out in an animal context? In CHILINSKI, we had a gentleman who was, who came to the attention of the DEA because he was growing a whole lot of pot on his property in in Montana. And as it turns out, when the DEA showed up to investigate this, they found he was also running a large husky puppy mill. And the issue confronting local authorities was, how do we hold all these dogs? These are not socialized dogs. They're scared of humans. We opened the pens. They're running all over. What do we do? And they were able to bring in local rescues, nonprofits, the Humane Society of the United States to help corral the dogs, identify them, and get the dogs to vets. And CHILINSKI, the defendant, challenged this on search and seizure grounds. And the courts found, applying the Wilson-Hamlin rule, that because the third parties were there to help deal with the dogs as evidence and as victims and control the scene, that their purpose was legitimate. They weren't there to videotape for their own purposes. They weren't there to take the dogs for their own purposes. They weren't there to fundraise off what was happening to the dogs. Their presence in the protected private space belonging to Mr. CHILINSKI was specifically to help law enforcement deal with all of these dogs, and therefore their presence was legitimate. So, some more implications: costs and logistics. As my very own puppy mill rescue dog Puck here can attest, your evidence in these cases is a who, and your evidence is going to be hungry. Unlike other evidence, you can't maintain your chain of custody just by sticking the dog or cat or what have you in an evidence locker and walking away. Your animals require ameliorative care to treat the suffering they've received. They require maintenance care to receive the minimum food, shelter, housing, and water that they would otherwise get. They need housing. They need permanent homes. They need to be socialized and given enrichment. And this all costs money. And particularly when you're dealing with a mass case, these are resources that your average county, your average city is not necessarily going to have. Having encountered, for example, horse hoarders, I can tell you that your average rural county is not prepared to take on 250 head of horses. So what do you do? How do you help counties deal with the problem of having custody of a lot of animals, having a legal obligation and an ethical obligation to feed and house and care for those animals, but not having the money to do it? The gold standard here is what's called a bond or forfeit statute. And this statute simply says to the defendant, look, while the government has custody of your animals, those animals are still your property. You're still responsible for giving them food, shelter, etc. And so we're going to ask you to post a bond to do that. If you choose not to post a bond, you will forfeit the animals. And at that point, the government can adopt them out, can put them in foster homes, can treat them like any other animal in the government's care. And that sort of pre-conviction forfeiture approach addresses the issue of otherwise the government or private rescues being on the hook to cover the care costs that the defendant otherwise legitimately should be taking care of. After the fact, way to deal with this is to do a care lien, the same sort of lien a veterinarian gets if you bring your animal in and then don't pay your vet bill. Your vet can theoretically foreclose on your ferret or your goat or your dog or what have you. That's messier, and it's for a variety of reasons much better to try to do this through bond or forfeit. So some case law on this. Some key cases, I'm going to talk about them both together, are Oregon v. BRANSTETTER and Tennessee versus NEUTZLER. And these both challenged bond or forfeit statutes on a variety of grounds, largely arguing that bond or forfeit should be considered a criminal matter and therefore should be subject to constitutional protections against excessive fines, rights to jury trial, and so forth. What courts have consistently found is that there's no excessive fine issue here because bond or forfeit is not a fine. It's not about punishing the defendant. It's simply about solving a practical problem. The question for bond or forfeit is not, defendant, did you abuse your animals? It's, defendant, you have a legal obligation to provide this animal with food, with water, with minimum shelter. The fact that the animal is in the custody of someone else doesn't absolve you of the fiscal responsibility. So if you want to pay for the animal, great. The animal continues to be your property. If you don't want to pay for the animal, there's a structure in place to prevent you from free riding off of the government or a private rescue's budget. In terms of a jury trial, similarly, resolving who pays for the animal is not a criminal matter. It's a civil matter. It runs parallel to a criminal case. It may be connected to a criminal case, but it is separate from the criminal case. So you do have a due process requirement. The defendant needs notice of the bond or forfeiture hearing. They need an opportunity to address the court, depending on the jurisdiction. They may be able to argue that the animals were inappropriately seized in the first place, or that the bond amount being asked for is too high. There's a whole range of legitimate arguments to make there, but because this is not criminal, there is no jury trial that needs to be undertaken in order to determine whether or not a bond should be put up to pay for the animal's care. And lastly, this sort of pre-conviction forfeiture is different than civil asset forfeiture. Civil asset forfeiture is an issue that you probably know is getting increasing attention in our public policy space, because it largely implicates issues of the government seizing property loosely related to crime and being able to keep that property for the government's own profit and benefit. And there's an argument about whether that is or is not legitimate and what sort of safeguards there are on that. That's really a different issue than the issue in this case. The interest being served in that case is, in theory, extinguishing the profits of criminal enterprise. For bond or forfeit, it's just making sure animals get the care they need. The state is not profiting off bond or forfeit. I have never seen a bond or forfeit case where the bond even came close to paying the actual costs of the animal's care. And finally, bond or forfeit applies to a very narrow range of property, unlike civil asset forfeiture, where the government can seize any property loosely related to a crime. Here, the only property implicated are the animals, because legally animals are property. So let's talk about merger and sentencing, because everyone loves talking about the minutia of criminal procedure, or at least I do. So what is merger? Merger is the concept, as applied in a lot of jurisdictions, that if you're engaged in multiple crimes during a single criminal episode, those all merge into a single conviction. So for example, this is why if someone walks into their local grocery store, walks out with a 6-pack of beer and doesn't pay for it, they get a single conviction for theft 3, not 6 different convictions for each can of beer. Because while you could theoretically charge them for every can of beer, it's one criminal episode, and all of those charges would merge down to one conviction. But there are typically exceptions to this, and one of the common exceptions is that you get a separate conviction for every victim involved. It's why you don't get to criminally assault a bunch of people in a brawl and only be convicted on the first person and get the rest for free. And so the question that arises in mass animal cruelty cases is, do animal crimes merge or not? There is, to my knowledge, no explicit animal exemption for merger. So the question we have to ask is there another relevant exemption? And there is case law on this. Specifically, I'll point you at Oregon versus Nix. The case facts in this are pretty straightforward. We've got starving goats and horses at a farm. The defendant is convicted on 20 counts of animal neglect. And at merger, the trial court says the only applicable exemption might be this multiple victim exemption, but animals aren't people under the law. And therefore, animals can't be victims, and therefore, all of these counts merge. Defendant, you neglected 20 different animals, but you're going to walk away with one conviction. The appellate court disagreed and found that animals were, in fact, the victims of animal cruelty. That your victim can't be the owner, because if your victim is the owner of an animal, you could never charge an owner with abusing their own animal. And we have laws specifically saying you don't get to abuse your own animal. Similarly, it doesn't make sense to say that the victim of animal cruelty is society at large, because we gradiate how bad an animal crime is based on not how impacted society is, but how much an animal suffers. The difference between neglect 1 and neglect 2, for example, is, does the animal die? Is the animal tortured by virtue of neglect, or does the animal simply suffer a lesser degree by virtue of the neglect. And therefore, because the animal is a victim of animal cruelty, the counts do not merge. The state Supreme Court upheld that, finding that the reason we have cruelty law is to protect animals. Therefore, animals are, for the purposes of cruelty crimes, crime victims. Therefore, we don't get merger. Now, an exciting citation note, and this is exciting for all of us because you are one of the few audiences that really appreciates why this matters. If you go looking for Oregon versus Nix, the first thing you will see is a giant red flag saying this is bad law. And that's because after everything was decided, it turned out that for procedural reasons unrelated to the substance of the case was inappropriately appealed. And so the Supreme Court vacated the ruling. However, in a subsequent case, State versus Hess, Oregon versus Hess, the court upheld the analysis of Nix. The court said, the appellate court in Oregon said, we recognize that Nix was inappropriately appealed and procedurally it was bad law, but we're just going to pick up the whole analysis from the Supreme Court opinion, plunk it into our opinion, and it's now good law again, and it goes forward. If you decide you need to cite this and you're trying to figure out how, send me an email. I have like a paragraph-sized footnote that lays it all out for you. So let's talk about prevention and intervention with our last 5 minutes or so before we get to Q&A. So there's some implications from these mass cases coming out of these mass cases for how we prevent and intervene with crimes. There's some policy implications in terms of trying to provide people with the education they need to know how animals should be cared for, the minimum requirements of food, shelter, and so forth. There's implications in terms of giving people access to resources, providing low or no cost care for animals, low or no cost spay or neuter options. All of these things go towards making it less likely that the crime ever occurs. If, for example, someone can easily get animals spayed or neutered, they're less likely to end up with more animals than they can possibly take care of and less likely to end up in a neglect situation. Similarly, providing mental health resources may help ameliorate some hoarding cases or some other cases where animal cruelty is related to mental health. In terms of statutory approaches, one really effective thing is to have a statutory recognition for animal sentience, because similar to what I just talked about in terms of animals as crime victims, having the state recognize that the existence of animals as sentient beings, recognize the legal significance of that, means that you have a statutory framework to say a case with a lot of victims is legally distinct from a case with a single victim. A case with a lot of suffering is legally distinct from a case with a little bit of suffering and should have a different kind of intervention. Statutes that require licensing and inspection for facilities that have a lot of animals can be very, very helpful. For example, if you have a statute that says any facility with more than half a dozen reproductively intact dogs is going to be defined as a dog kennel, and you need your kennel to be licensed and your kennel is subject to inspections, that gives you a framework to get eyes inside rescue facilities, to get eyes inside breeding facilities, and determine that they are meeting their minimum obligations under the law. It also lets you have administrative searches, which sidesteps a lot of your search and seizure issues. Finally, courtroom animal advocate programs, the first of which was Desmond's Law in Connecticut, followed most recently by Frankie's Law in Maine. These are programs that allow attorneys on a pro bono basis and law students on a pro bono supervised basis to act as the advocates for animals in criminal cases. Here you can see Desmond, the dog for which the first of these laws was named, and you can see Professor Jessica Rubin from the University of Connecticut Law School and one of her students arguing for an animal in court. This is a big deal. This is one of the only places where animals are represented as quasi-parties themselves and are recognized as having standing. It's also one of the only places where a victim gets to directly have their own representation and directly address the court. And in this context, they get to speak for the interests of the animal victim, which are distinct from the interests of the prosecution and the interests of the defense. For example, they get to talk about things like, where does the animal live? Is the animal getting veterinary care? Will this animal and other animals be protected by the defendant being issued an order that says they can't possess animals? And that may be different than the state's interest in whether the defendant spends time incarcerated or not, or how much time that is. It may be different than the defendant's interest in arguing whether they did the crime or did not do the crime, and so forth. And this really, I think, points us towards a sentencing model that focuses on vindicating the animal victims and preventing future harms. There are a lot of peniological goals involved in the criminal justice system. There are a lot of reasons we construct sentences. I would argue from the animal perspective, we need to bear in mind these two issues, vindicating the animal victim's interest and preventing future harms. I'm going to wrap up by talking about some case law relevant to this, and then we'll do questions. So the case I want to talk about this is the charmingly named US versus approximately 53 Pit Bulldogs. And this case comes out of the Michael Vick dogfighting ring. There's a whole criminal case involving Michael Vick, and that doesn't really matter for the purposes of what I want to talk about today. What matters in terms of animal law, precedentially, is the civil track. And the question there wasn't, was the defendant involved in dogfighting? How did the criminal case work? The question was just, we've got 53 dogs that were involved in dogfighting. They're contraband. What do you do with them? Prior to this case, the standard was that dogs involved in dogfighting were thought to be irredeemable. They were thought to be inherently aggressive, and they were mass euthanized. What happened in this case, uniquely because it was a federal case and because the defendant had the resources to potentially pay for rehabilitating the dogs, is the judge appointed a law professor, Rebecca Huss, who you can see here with one of the dogs in a photo, appointed her as a special master to assist the court in determining what the dog's interests and needs were. And so for the first time, there was an attorney whose job was actually to bring the court's attention to the needs of animals in a case like this, the needs of the animal's victims. And the result was a determination that these dogs in almost every instance could be rehabilitated. Of the 53, 2 dogs had to be euthanized for health reasons because they had been subject to abuse and neglect so severe that they couldn't live healthy, non-suffering lives. 1 dog ultimately was euthanized for behavioral reasons. The dog had some mental issues that simply couldn't be treated. The other dogs were all able to either be adopted out or live out their lives with animal rescues. Many of them went on to be therapy dogs. And it caused a sea change in how dogfighting cases are handled nationwide. Sports Illustrated, for example, went in the space of a year from this being the face of dogfighting in their coverage to this on the bottom being the face of dogfighting. And the default nationally went from you kill every dog you seize in a fighting case to you rehabilitate those dogs. You don't make the dogs die because of what's been done to them. You get them the help they need. And that, I think, is really a great model for this sort of animal victim representation approach under the law that we see happening in Connecticut, we see happening in Maine. And that is, speaking personally, a project that I put a lot of effort and energy into is expanding those programs nationwide and supporting those programs. So I hope we see those in more states and we provide more opportunities for attorneys and law students to do this kind of really rewarding work. And with that, talk about any questions you might have. And my headset just told me that my battery is dying. So if at any point you can no longer hear me, please say something and I'll just switch to like regular headphones. It'll be great. So what's on your minds?
I had a question.
Yeah.
Relating back to that conversation about farm animals. And I'm thinking if there is a case of like recognizing animal abuse in some sort of farm, pigs, cows, chickens, or anything like that, what happens to those animals? Would the farmers be like required to just adjust the conditions? Are those animals moved to a different farm?
So I'll, not to be the stereotypical lawyer, but I'll answer it in two ways, which is like the stereotypical lawyer thing to do. So the animals that are the victims of that crime, the animals that are the basis of the charges, are potentially going to be seized and subject to the same sort of pre-conviction forfeiture process that you might see in a companion animal case. So they can be housed at farm rescues. They might be housed by the state, pending the outcome of that process of determining who owns them. And once that's resolved, they can be adopted out to live their lives. If the resolution is, defendant, you are not able to possess animals, or defendant, you forfeit these animals, then the government figures out the disposition. And the disposition is often going to be, we provide them to animal rescues. We allow people who want to adopt them to purchase them or adopt them depending on the jurisdiction. This is assuming the animals are able to survive in a healthy, happy state. The question of what happens to future animals is potentially separate. And there the issue is going to be, is that defendant prohibited from possessing or controlling animals as a result of their sentence? And that's really going to depend on the individual case and the individual jurisdiction. Some jurisdictions have mandatory possession bans that will be triggered like at a felony level, but also some of those mandatory bans have exemptions for farmed animals, because when you are passing such a ban, the farm lobby becomes very concerned that you're going to deprive their members of their livelihood, and this leads to a very ugly legislative fight. So usually the way that works out is some sort of narrowing or exemption where the state will need to make an additional showing of why this person can't have possession of animals, or why they are uniquely dangerous for animals that would be in their care. But yeah, by and large, it's the same process you follow for companion animals. And I've seen cases where horses, geese, pigs, ducks, goats, rabbits, all manner of farmed animals get adopted out into rescues, and we could pleasingly get video and photo of them frolicking with their new people afterwards. The animals, I will say, the animals most at risk of not going into some sort of post, like after you get their who owns them resolved, post property interest hearing, adoptive home, are cockfighting birds. Because there aren't a lot of adoptive homes for birds, because roosters are birds you can't have in a lot of places. A lot of zoning laws prohibit you from having roosters because they're noisy. And because with cockfighting birds, you usually can't house them together because they've been trained to attack each other. And so in a lot of jurisdictions, it's still the case, much like it was for dogfighting dogs years back, it's still the case that a lot of those birds are euthanized. There are some outfits that are working on rehabilitation and rehoming for cockfighting birds, and that's an area I'm hoping we'll see much more work in, because those birds shouldn't be killed just because they had the misfortune to be exploited by fighters. Any other questions? Anything else on your mind?
I had a question about going back to the statutes. You talked about like the sentence recognition and those kinds of statutes. In states where those statutes don't exist, what generally are like the things you can do or routes that organizations like yours take?
Just a second. I'm gonna switch my audio so I can still hear you.
Okay.
No. Sorry, I just lost audio on you. Give me 1 second.
Oh, no problem.
Could you say something there? I'll see if I can hear you.
Yeah, can you hear me now?
I can.
Okay.
Perfect. Thank you very much. I'm sorry. So I got you were asking what happens in a jurisdiction without a sentient statute, and then that's when my headphones died.
Yeah, just basically what kind of steps can be taken, or does your organization do anything to kind of try to get those statutes in place in states
Yeah.
that don't exist?
Yeah, so I'll take the last part of that first, since it's the fastest. We absolutely try to pass those statutes. That's really whatever we're doing an update with the state on cruelty law, we always try to get that kind of statute put in because it's intuitive. There's not a lot of people that are going to argue that animals are things, that animals don't experience the world, that animals can't experience pain and pleasure and fear and safety, and because it makes a big difference. So it's a relatively low bar in terms of a legislative ask with a big payoff. In terms of what we do in jurisdictions that don't have that kind of law in place already, we do the legwork to make the argument in court. So even if there isn't a legislative finding from lawmakers saying animals are sentient, they can experience pain, they can experience fear, therefore it's the policy of our great state that they be protected from fear and pain by not being subject to inhumane treatment at human hands. Even if that kind of law doesn't exist, we can still go to the court and say, here's a bunch of scientific data that shows that animals experience pain, fear, so forth. We can bring you all the veterinary experts you want to talk about how starving is painful. Starving causes terror. Being subject to torture is unpleasant. Again, intuitive things, but things you may need to get on the record. And then we will argue based on that and based on the fact that, for example, the statutory severity of your cruelty crimes increase with that sort of suffering, the court should find that animals are, for example, victims for sentencing purposes and act accordingly. And we've worked with attorneys in a variety of venues for that. So in Oregon, we've got State versus Nix that reached the decision that animals are crime victims as a matter of case law. We're seeing similar arguments, for example, in federal court over dogfighting cases. And we've weighed in there. And it really does come down to being able to argue that animals are victims of animal cruelty because they are sentient. Maybe society is a separate victim. Certainly, if the owner of the animal is not the perpetrator, the owner is also a victim. If someone tortures your cat or kills your dog, both the animal and you are victims. But our argument is that doesn't preclude animal victimhood. And it's important to acknowledge animal victimhood and legally vindicate that in the spaces that our legal system accounts for victims.
I have another question, hopefully a quick one, but do you or can you elaborate maybe or explain what the intersection of animal rights law would be and environmental law? Because I see that being a huge area.
Yeah, there's quite a lot of intersection. And so part of it is, not to get too like law professor geeky on you, and I'll give you the caveat, I do teach animal law courses as well. So I guess I am the aforementioned law professor geek, because I love the law history about this. So part of it is that animal law as a field grows out of environmental law. So we trace our historical roots back to the environmental law field. We've built on a lot of work they've done, but there are differences. And so I'll tell you this anecdote to give you, because I think it's a great way to sum up what those differences are. I was at a symposium on the Endangered Species Act a few years ago. And this symposium had animal lawyers and environmental lawyers. And one of the speakers was discussing the plight of red wolves in the Carolinas. Red wolves are an endangered wolf species. And they're threatened by a lot of things. They're threatened by urban encroachment, environmental destruction, illegal hunting. They're also threatened as a genetic species because they're interbreeding with coyotes. And then instead of red wolves, you have coyote wolf hybrids. And so the speaker, who is an environmental lawyer, said, so, we're trying to preserve the species of red wolf. So one of the things that we do is, as wildlife agents are going about their business in the forests, in the bush, when they find these coyote red wolf puppies, they euthanize them. And looking around the room, you could see the environmental lawyers sort of nodding, being like, I mean, yeah, that preserves the species. And you could see the animal lawyers just like with their jaws open, because it comes down to a species versus individual perspective. And I think that animal lawyers tend to take a more, how do we advance the interests of animals as individuals perspective versus the interest of animals as a species category. That said, protecting animals as individuals also tends to protect them as a species. And cases like this coyote red wolf scenario aside, often protecting species also protect individuals. So being able to vindicate the rights of animals under the law is relevant to environmental work in many cases, because it lets you protect the animals that you want to survive, to serve the needs of the environment, to serve the needs of the species. Conversely, the arguments that I make about wildlife crime depend on environmental law. Wildlife crimes, whether it's the ESA, whether it's anti-poaching law, whether it's the Migratory Bird Treaty Act, the Eagle Protection Act, none of these are laws that were passed for individual animals. These are all environmental laws, but they do allow me the space to argue that an animal hunted in violation of those laws was also subject to animal cruelty in jurisdictions where the cruelty exemption says hunting is not cruel when the hunt is legal. So I can say, well, the hunt wasn't legal, therefore our society has decided that the cruelty you inflicted wasn't justified, and you should have to acknowledge both the resource theft and the environmental damage you've done. You should also have to be accountable towards the animal that you treated cruelly. So I think the short answer is we are closely allied fields that benefit a lot from each other's work, but we also approach things in sometimes slightly different ways. And I think that, on behalf of the animals and the law as the whole, I think that having both perspectives gives us a better outcome.
No, that was great. Thank you.
I'm not sure if you saw, but I think Professor Fishman put a question in the chat for you.
Oh, I did not. Let me pop the chat up.
Oh, but that's me. Hi. Only if the students are done with their questions.
I have one quick question. Okay. So I was wondering, like, do you see a lot of cases with like cosmetic, like backgrounds with like animal testing and that kind of thing?
We don't, and there's a few reasons for that. One of it is on a statutory basis, what could be broadly termed scientific testing, scientific research is often exempt from cruelty, to the extent that you're doing it as part of the experiment. If something happens to an animal, much like farming, you don't get to do whatever you want to an animal and excuse it just because the animal's in a lab, but the animal's experience as part of the experiment is usually going to be exempted, assuming the experiment is checking off all the other boxes required. The other reason is practically, it's very hard to know what's happening inside labs. So even when something is happening that wouldn't be subject to an exemption, witnesses don't necessarily come forward. The state doesn't necessarily find out about it. You often need a whistleblower to come forward and say, well, we've got rabbits that we are doing testing on. The testing isn't the criminal issue. It's that last week, no one remembered to hook up the water feeder for the rabbits, and they all died of dehydration. That would be a neglect charge, but we're never going to find out about it unless a whistleblower contacts us. Or you have someone doing the kind of undercover footage that you see coming out of a variety of outfits doing employment-based investigations in typically agriculture, but also sometimes research facilities. And I think the third reason is that companies are moving away from animal testing. Increasingly, there is less need to do that. If, for example, you are trying to figure out what your cosmetic does to human skin tissue, at this point, you can grow human skin tissue in a vat and put your cosmetic on it and see what happens. You don't necessarily need to test that on an animal whose skin is not human and may not react the same way.
I actually have a question as well. So animal abuse cases are very emotionally taxing. How do you deal with that emotional burden?
They are very emotionally taxing. So one of the ways I deal with that is, as you can see in this photo, I have these two dogs. I have the dog you saw earlier. I've got some cats. I take breaks. I go, I hug my dogs. I think, you are safe, and that is good. And I also remember, and I think this is important for all of us doing legal work, when you are confronted by the awful stuff that may come up, because people don't come to lawyers at the best moments in their lives. People come to lawyers when they have a problem. It's important to identify the moments when the work you're doing has an impact and hold on to those. And sometimes I mean that literally, like keep a file of emails from your clients thanking you for the work you've done. Keep a file of news stories talking about the outcomes of your cases, because it's easy to lose perspective when you're in the middle of a case. And also remember that you are part of a legal community, and you don't, no matter what kind of law you're doing, you don't have to be dealing with the pressure of that alone. I would imagine that most state bars have resources available to their members for professional support in terms of responding to the emotional taxing need of cases, and certainly bearing in mind your ethical obligations of confidentiality, navigating that appropriately. You could turn to your colleagues and talk to them about what's going on. Knowing that other people are in this with you helps a lot.
Thank you.
I just have a quick general question. What, just generally, like what advice would you have for law students who would be interested in going into a field like animal law?
Sure. So I think the first question is whether you want to be a full-time animal lawyer or whether you want to be a lawyer who does animal law, because those are slightly different. Animal law, I would argue, is a different way of organizing the law than we're usually used to. Usually we think of the law vertically. So if you're doing criminal law, you might be doing prosecution or defense or victims law, or you might be helping write legislation, but it's all crimes. If you're doing estates, you might be helping write wills or challenging estates or managing trusts, but it's all someone died, what happens to their stuff. And animal law is horizontal. Animal law might be, we've got an animal victim of cruelty, we've got someone who wants to provide for their animal in their will, we've got a contract issue over who owns the unborn offspring of an animal that was purchased, and so forth. And that means that nearly every area of the law that you might otherwise do is going to involve animal cases. And the animal law perspective of that would simply be coming at it from a place that says the animalness of a creature is legally relevant and should have an impact on the case. So if you have someone who wants to provide for an animal after their death, that should be legally different than trying to leave property to other property. Typically you can't do that. You can't leave your car to your house, but you can, in every state in the country, set up some sort of trust to account for a companion animal. Similarly, as we've discussed under criminal law, we should be able to account for the sentience, the animalness of animals. So you could do that in your standard practice by bringing that kind of attention to bear. And you can carve out good niches for that. I know people who do estate law, and their whole pitch to clients is, you could find a number of attorneys in this town to help you do a will. You're not going to find anyone else who has the specific knowledge to address the needs of your companion animals. In terms of doing full-time animal work, you're looking at trying to get on with one of the organizations, typically nonprofits, that makes that their business. And the best thing you could do is start networking, start clerking, start making some of these connections early, but also know that it's never too late in your career to shift. The head of our litigation team here at the Animal Legal Defense Fund came from a big firm background. He did big law for many years. That was his career. He paid off all his loans. He reached a point in his life where he was like, I think I want to help some animals. And he contacted us, and he's got a very impressive resume as a litigator. He's really good at what he does. And so we were happy to have him come in as part of our litigation team. And now he runs the whole program. So don't think that you need to start doing it now, but if you want to start doing it now, you can. And with that, I should note that ALDF, as many of my sort of parallel organizations, we will be posting for summer clerkships in the coming weeks. So keep an eye out for that if that's something that's interesting to you.
Thank you.
All right, we are about 15 minutes over. Feel free to keep asking questions if you would like, but also don't feel like you need to stay logged in here. David, I saw that your email is up on the PowerPoint. Is it okay if everyone takes that down and can forward their questions to you?
Absolutely, yeah. Feel free to email me. That's what we're here for. And if what you're trying to ask me is something outside my area, I'll get you in touch with one of my colleagues who may have a better idea.
Great. And then Professor Fishman actually needed to leave, but I copied down his question from the chat, and I'll probably just email that to you to get your thoughts, and I can get a response back to him afterwards.
That'd be great.
All right. Well, thank you everyone so much for joining us. Thank you again. That was a great presentation. And everyone enjoy the rest of your Friday afternoon.
Yeah, thank you all.
Thank you.